Yes, Lord Faulkner.
My Lord and my Lady, I was referring to the Court of Appeal in this case, which is MS page number 168, which is in flag 8 in the core bundle, page 14. And I was going to refer to paras 44 to 50. I don't invite your Lordship and your Ladyship to read it again, but I would imagine that you've had an opportunity to read it. In essence, what the argument that Lord Justice Floyd is dealing with there is to say, well, these are two separate issues, and he says, no, they're not separate issues, or they're separate issues, but there's one claim, and the claim is the validity of the notices. So all three courts that have considered this case already have understood the two separate issues being raised, but have treated them as all, in effect, going to the one claim, which is the validity claim. And I am submitting that the validity claim is how you characterise the proceedings for the purposes of Article 24.2. I don't know if Lord Sales was about to ask me a question.
No, I wasn't.
Sorry.
I was making a note of what you were saying.
And I submit that is the right way to deal with it. And I've given answers to Lord Sales's question. Just one further point in relation to the situation where you've got a Greek company with issues that might affect how that Greek company votes its shares in 10 separate subsidiaries. If the issue is mental capacity, then it plainly should be the law of the local state of the subsidiary that should determine mental capacity, not Greek law, because you're dealing with the local state. And as I've already indicated, you can also deal with it by Article 30. My Lord, my Lady, can I go on and make submissions under four heads? First of all, what's the correct approach to the construction of Article 24.2? Secondly, what's the correct analysis of these proceedings? Thirdly, a consideration of appeal ground 1, which is in effect a failure to treat the authority claim as distinct from the company law claim. And then finally, consideration of ground 2 of appeal, which is the wrongfully keeping the former trustees in the proceedings on the basis they weren't necessary parties, which is the second broad head of appeal. My Lord and my Lady, there's a broad measure of agreement about certain issues in relation to the approach to the law. First of all, these recast regulations must be construed independently of domestic law, as they're part of autonomous EU law. Secondly, they're intended to unify the rules of jurisdiction across 27 countries in a way which is highly predictable. That's preamble para 15. They pursue an objective of legal certainty. That's Eon at paragraph 28. I don't ask you to look at it because you've already seen it, which is MS 827. By enabling the applicant, that's the claimant in litigation, easily to identify the court in which it may sue, and also for the defendant in litigation reasonably to foresee in which court it may be sued. That's, again, Eon at para 28, the recast regulations preamble paragraph 4, and it's paragraph 15 to 16 as well of the recast regulations preamble. The provisions have got to be construed to give effect to the purpose and general scheme of the rules. That's BVG at paragraph 28. This does not mean always going for the literal or narrow construction. Instead, it means giving a meaning consonant with its purpose and object. And see the result in Eon, where what the Court of Justice were dealing with in Eon is the fact that there was a provision of Czech law, which said that where the court orders a different consideration for the minority shareholders, that doesn't render the decision of the company in general meeting, quote, invalid. So they were wrestling with the proposition, this doesn't affect validity of any organ of the state, of the company, sorry. Nevertheless, they held it's within the meaning of 24.2, because that's what you'd expect, where what you're dealing with is what they call squeeze-out provisions in Czech law. The next proposition is that the key purpose and general scheme, which is relevant for this case, is that the normal rule is that the defendant should be sued in the state of his domicile, but there are exceptionally 5 cases where a court is to have exclusive jurisdiction, regardless of the domicile of the defendant. The court should construe the 524 exceptions as being no wider than is necessary to give effect to their objective. The principle, quote, of sound justice justifies these exceptions, overriding the principle of being sued in the defendant's domicile, but only to the extent necessary to give effect to the objective of the exceptions. BVG decides, and again, this is, I think, implicit in all that I've said before, Article 24.2 is to be interpreted by taking account of matters other than simply its wording, in particular, the purpose and general scheme of the regulation, and that's para 29 of BVG, which is at MS 819. And then para 10, the specific objective of 24.2 is to centralise jurisdiction to adjudicate upon disputes concerning the existence of a company, the validity of the decisions of its organs, or of its dissolution, in order to avoid conflicting decisions. And it's just worth looking at the 3 bits that say that, which is in Authorities Bundle 2. First of all, BVG at MS 821. I invite you to read paragraph 40, which is the ECJ saying what the purpose or the underlying objective of 24.2 is. If you also look at Hassett 885, para 21, which is the bottom of the page, which expands on that slightly.
Are you going to come to paragraph 26 of Hassett?
I am going to come to paragraph 26
okay.
of Hassett, yes.
I'll be patient in that case.
Can I come back to that, if I may? I'm sorry to yeah. And then could I also ask you to look at Genar, which is in flag 27, at page 1002, MS 1002. It may be just Article 16 is the predecessor of Article 24. On the left-hand side, on 1001, Professor Genar sets out what the basic purpose of all 5 exceptions is. Makes the point that you can't get out of them by submission or by agreement. And they apply to everybody. And then if you go to 1002, the 2 paragraphs on the right-hand side, companies and associations of natural or legal persons, the first paragraph, then the second, it's important in the interests of legal certainty to avoid conflicting judgments being given as regards the existence of a company or association or as regards the validity of the decisions of its organs. For this reason, it is obviously preferable that all proceedings should take place in the courts of the state in which the company or association has its seat. It is in that state that information about the company or association will have been notified and made public. Moreover, the rule adopted will more often than not result in the application of the traditional maxim actor sequitur forum rei. Such jurisdiction is recognised in particular in German law and as regards non-profit making organisations in Luxembourg law. So I rely on those bits of material that I've said is that what you're looking for is, as it were, one, and this is the wrong word, but one constitutional court to determine what goes on in relation to the constitution and activities of a company. Now, it is not enough that the proceedings have amongst the issues they raise matters which fall within 24(2). Only proceedings whose principal subject matter is the validity of the constitution of the company or the validity of the decisions of its organs fall within the exception. It's not enough that the proceedings raise as one among other issues a 24(2) issue. And that is primarily BVG in the ECJ or CJEU. Could I just show you bits of BVG? They set out the questions. Then if I could take you to MS number 8, page 818, which is 2092 in the report. It's flag 15 in Authorities Bundle, Volume 2. Paragraph, it's to be observed at the outset, in the present case, 3 questions have been asked relating to the interpretation of Regulation 44201 in the context of the main proceedings between BVG and JPM concerning the swap contract, which is a financial derivative contract. And this is the bit I particularly rely on. After JPM brought an action before the English courts designed essentially to enforce the contract on the basis of a clause conferring jurisdiction contained in the contract, BVG brought a parallel action asking the German courts to declare the same contract void on the basis, in particular, that its subject matter is said to be ultra vires in the light of BVG's statute. So there were, in fact, 2 separate proceedings in the BVG case, one in England where they were seeking to enforce the contract, and one in Berlin where they were seeking to get a declaration that the contract was invalid as a result of the capacity issue. And then could I invite you to look at 26 and 27 at the top of page 819. As regards the wording of 22.2, there is a certain divergence among the various language versions of that provision. According to some of the language versions, the courts where a company or other legal person or an association of natural or legal persons has its seats have exclusive jurisdiction, quote, in the matter of the validity of its constitution, its nullity or its dissolution, or the validity of the decisions of its organs. By contrast, other language versions provide for such jurisdiction where proceedings have such matters as their, quote, object or subject matter. The second of those forms of wording suggests, unlike the first, that only proceedings which the validity of a company's constitution or of a decision of a company's organ is raised as the primary issue are covered by that provision of Regulation number 442001. What I submit the ECJ is doing there is saying you've got a choice here. You can either go for a construction that says, is it one of the issues raised, and it could be within 24(2), or is it what the case is about? If one then goes to para 44 in the judgment,
page
MS 821.
Thank you.
Thus, the divergence noted in paragraph 26 of the present judgment, which is the one I just referred you to, between the language versions of Article 22, is to be resolved by interpreting that provision as covering only proceedings whose principal subject matter comprises the validity of the Constitution, the nullity or the dissolution of the company, legal person or association, or the validity of the decision of its organs. He then refers to the patent law exception. And it's a significant distinction he's drawing, because what they are saying is in relation to patent law, wherever there is an issue about patent law, which is the fourth of the exceptions in Article 24, if it's raised, even though it's not the primary purpose of the proceedings, then it's exclusive jurisdiction in the court of the patent. But that is not the case, the court is saying, in relation to the company law issues. In order for the company law issue exception to apply, it's got to be what the case is about. Now, what does that mean in relation to BVG? In my respectful submission, what it means in relation to BVG is that even assume the only issue in answer to the contract was the capacity to enter into the transaction, it would still be properly analysed as a contract claim, not a 24(2) claim.
Do we know if there were other issues in BVG?
Yes, there were other issues. One of the other issues was whether or not JP Morgan had given negligent advice to the BVG, I think it's the Berlin Public Mass Transport Company. So there were other issues. It's true to say that the Court of Appeal took the view that probably that would not be the main issue in the case, but there were other issues in the case. But in my respectful submission, it's key that what they are saying here is this is a contract claim. If you go back to 22, which I referred you to.
It's quite dangerous to read paragraph 47 and interpret it as a statute, as it were entirely divorced from any understanding of what the issues were in the case.
Yeah, I mean, if you just to give a sort of clearer view about what the issues in the case were, it's worth maybe, and I don't invite you to do it now, perhaps, but
no,
go
but if
to
you give me
BVG
some
in the Court of
references.
Appeal, and you find BVG in the Court of Appeal at flag 8, thank you very much indeed, which is MS 608.
Yes.
But there were other issues. And interesting enough, the Supreme Court here referred BVG to the European Court of Justice, but then withdrew the reference once the court had ruled on the Berlin proceedings, which is where they had said this is a contract claim. So what I say about BVG is it supports my contention that you try and analyse what the basic claim is about. You don't try to evaluate which is the most important issue within the claim. If you go to Hassett next, what Hassett, as I understand Hassett, there's a claim by a patient for being treated negligently by an Irish hospital. The Irish hospital board then brings in the doctors, the Irish hospital board having settled with the patient. The doctors then try to bring in the MDU, saying you, the MDU, have failed to agree to indemnify us, the doctors, in relation to what we owe the Irish Health Board for our negligent treatment of the patients. The patients having settled with the health board, and the health board then trying to get recovery from the doctors. In essence, I submit that what the CJEU is deciding is this is a claim about the relationship, contractual and semi-contractual, between the doctors and the MDU. It has nothing to do with the validity of the decisions of the MDU in a corporate sense. I'm not sure if the MDU is a limited company, but it's a corporation of some sort. And therefore, it's got nothing to do with 24(2). And what's more, the courts, in considering these jurisdiction issues, should be very careful not to allow issues which are, in essence, contractual disputes or something like them between a company and an outsider to be characterised as 24(2) issues simply because you then raise an issue about whether or not the decision made was valid within company law terms.
Can you help me? These are all cases in which there's one company involved.
Yes.
There are two companies involved in
Yes.
the present litigation.
Yes.
And on one analysis of the issues, you could say that the validity that we're looking at is of the organs of the Turkish company.
Yeah. I submit
How does that fit?
That is wrong, I respectfully submit, because the issue in the proceedings, these are the English proceedings around whose jurisdiction we are circling, is the notices served within Koza Limited's terms valid? Because the issue in the case, the issue in respect of which the injunction was sought and granted by Miss Justice Snowden, and the issue that is being sought in the proceedings is to stop, in effect, a shareholder in Koza Limited appointing a different director. The issue in the case is the appointment or the proposed appointment of the director of Koza Limited valid or not? And that is a question about the validity or otherwise of the organs of Koza Limited, not the validity or otherwise of the organs of Koza Ltd.
But I think the appellant says against you, there isn't a notice at all. That's the question. There is no notice from Koza Ltd. That it takes it one stage back.
Well, no, but what I am the claimant. What am I seeking to say? I am seeking to say that the notice issued by Koza Ltd as shareholder of Koza Limited is invalid. The question for the court is that notice valid or not?
But can it turn solely on what the claimant is seeking to say? Mustn't it also involve an assessment of what the defence is? And the claimant may say, I want damages for breach of contract.
Yeah.
The defendant may say, the only defence I've got is that I didn't validly enter the contract because if it's a company, the person who signed it wasn't my validly appointed director. I accept otherwise that I'm banged to rights for precisely the sum which you're claiming.
Yes.
Now, can one really say that claim is principally about breach of contract?
Well, that is what BVG says.
Well,
BVG
no, because there were other issues.
Well, there was the issue about, but it's not it's not a question. If you read the Court of Justice in BVG about weighing up which is the more important issue.
Didn't they say that the Varies issue at the end of the day was ancillary?
Yes, they did.
Well, ancillary to what?
The contract claim. They're saying you've got to analyse the claim properly and work out what is the primary claim that is being made. If you, for example, take the approach that my Lord Briggs is suggesting, then take as your first proposition, you need to know where you want to start your claim. You can't tell on the analysis given by Lord Briggs where you start your claim. It must be primarily, if not exclusively, based on where you bring the claim, where the claimant brings the claim, and a proper analysis of what that is. There's a secondary point in relation to the point made by my Lord Briggs, which is if you attack jurisdiction, you will very often attack jurisdiction on the basis of not putting in a defence. That's in England, certainly, and I would imagine that's quite common in quite a lot of these places. I don't mean these places, quite a lot of states within the European Union. It couldn't be the case, I respectfully submit, if you were seeking to synthesise jurisdictional law right across, that you have one conclusion based upon the claim and then a second conclusion at the point that a defence is put in. It doesn't depend on what are the specific issues in the sense of what is left. It depends upon the nature of the claim.
I mean, when you look at BVG, the dispositif is laying down a rule. It's got nothing to do with distinctions between primary and ancillary claims or the existence of alternative of other issues in the case. And it's on page 822, and it's a ruling that the regulation must be interpreted as not applying to proceedings in which a company pleads that a contract cannot be relied upon against it because the decision of its organs which led to the conclusion of the contract is supposedly invalid on account of infringement of its statutes. So that's that.
That is that, and I embrace what my Lord Reid has said. with respect, I agree with the implication of what you are saying, which is if it's a contract claim, even though it's a capacity issue that's the defence, even if it's the only defence, that does not detract from the proposition that you've got to analyse the claim. And for all the reasons I've just gone through in answer to my noble Lord Briggs, that's a sensible conclusion.
Yes, and if you're looking for legal certainty as to where to raise the action and foreseeability of where you're going to be sued, then you need to look at what is the claim that's going to be raised.
Exactly.
Well, I can see that, but the trouble we know in real life is that the claimant, let's say the party A, makes a claim characterised as a contract claim in England, and on the same day, party B, who's the defendant in A against B, and the claimant in B against A, makes a claim in Greece, which is all about validity of its organs, but with consequences for the outcome of the AB claim. Now, it just so happens that party B puts what will be his defence in England as his claim in Greece.
Yeah, but they deal with that in BVG. They're saying, in effect, look, this is exactly what they did in BVG. They began proceedings in Berlin to say, declare I didn't have the status to do it. Didn't work because it was obviously part and parcel of the contractual dispute. And that's what the CJEU is saying. And it's completely consistent with them saying, don't be misled by people trying to suggest an invalidity issue changes the characterisation of the dispute. Could I refer your lordships to paragraph 34 of BVG in the CJEU, that's at MS 820. And 35, it's sort of making the point that my Lord Reid was making.
Yeah.
And then, unless anybody wants to look at BVG and the CJU further, could I take you to Hassett now again? I submit that Hassett is really about contractual rights or something similar owed by the MDU to the doctors. If one goes, first of all, to para 14, this is, it's flag 19, MS 883, just to 13 and 14 say what the parties argued. "15 is the question. Then 16 is, my friend Mr. Crowe rightly says, the court cannot resist the temptation in every case to rephrase the question, presumably on the basis it's an autonomous court, and therefore all to try and bring it all together. They make the point it's autonomous in paragraph 17. And 18, moreover, as stated in the 11th recital, in accordance with the general rule, moreover, as stated in the 11th recital of the preamble to regulations, jurisdiction based on the defendant's domicile, in accordance with the general rule, must always be available, save in a few well-defined situations in which the subject matter of the litigation or the autonomy of the parties warrants a different linking factor. Such situations must accordingly be interpreted strictly. Just en passant, I can't remember if there's a word, if it says narrowly anywhere, but strictly is referred to quite frequently in the cases. And I submit that what that means is you've got to be focused on what the purpose is. And then para 19, and I'm just reading from the middle, the court held in that regard that as those provisions of the Brussels Convention introduce an exception to the general rule governing the attribution of jurisdiction, they must not be given an interpretation broader than is required by their objective, since their effect is to deprive the parties of the choice of forum which would otherwise be theirs, and in certain cases they result in the parties being brought before a court which is not that of the domicile of any of them. And then 20, the essential objective pursued is one of centralising jurisdiction in order to avoid conflicting judgments. And then I think I don't need to read any more of that because we've gone through that so often. And then 23, as submitted by the doctors, if all disputes involving a decision by an organ of a company had to be treated as coming within the scope of point 2 of Article 22 of Regulation 44, that would in reality mean that all legal actions brought against a company, whether in matters related to contract or tort or delict or any other matter, would almost certainly come within the jurisdiction of the courts of the member state in which the company has its seat. That's the sort of gypsy warning. Don't allow the thing being characterised as a validity issue to bring it within 24.2. There's got to be something more than that. And I submit that something more is the claim based upon issues concerning whether or not something is either determinative of whether a company exists or whether one of its organs' actions is valid.
Well, the court itself tells us what the key is, I think, in paragraph 26.
It must be in terms covering only disputes in which a party is challenging the validity of a decision of an organ of a company under the company law applicable or under the provisions governing the functioning of its organs as laid down in its articles of association. Precisely right. So what is happening here is the two notices, 303 and 305, valid in accordance with English company law? And they are only valid in accordance with English company law if they represent a 5% or more shareholding. They're authenticated by the person moving the notice, and the motion that they seek to move is one that can validly be passed. And the authority issue and the company law issue, which is can you change Article 26, or is the motion moved in accordance with Article 26, both raise questions of the validity of what the organs can do in accordance with English company law. You shouldn't, sorry.
And that paragraph gets cited in the later case law.
Yes.
In Eon and
Yes.
Sky Lau.
And
Sky Lau.
yeah. Yeah.
So do you say that if you have an issue about, for example, the mental capacity of a shareholder, or whether the company which is the shareholder is being managed by people who are validly appointed under Turkish law, that what is then involved is a challenge to the validity of the decision of an organ of the English company under English company law or under the provisions laid down in the English company's Articles of Association?
Yes, I do, because it is English law that determines whether or not English law, whether they will recognise the validity of the notices. That is an English law question. The fact that as a matter of, I mean, as it happens, in every aspect of this is English law, because although obviously along the way the court may have to decide what Turkish law is, nevertheless the question of whether or not the English court recognises the trustees as being authorised to act, it's not a company law point, is a matter to be determined by English law. So the question of whether or not the English courts would recognise the authority of the trustees, in effect, depends upon, do the English courts recognise the validity of the appointments of the trustees, primarily by a series of Turkish courts. And that is a matter of English public policy, England's view of how the Human Rights Act intersects with that, matters of English private international law as to the extent to which they will recognise the judgments of foreign courts.
So really you treat the references here to company law, English company law, and the Articles of Association of the English company as enabling you to go beyond company law and the articles themselves to any other legal materials that would bear on the on the validity of the decision.
Yes, and I say that for two reasons. First, very frequently, it will be the case that issues of foreign law could arise. For example, where there is a contract governed by a foreign law which determines whether shares are paid up or not, and that might be relevant to whether or not a 5% or more shareholder had issued a notice. The fact that there is a foreign law issue on the way there doesn't detract from the proposition that ultimately it is English company law that determines the validity or otherwise of the notice. And secondly and separately, the purpose of these provisions, by which I mean 24(2), is to centralise on one court decision-making in relation to the validity of the organs of the company or the existence of the company. So, go back to my Lord Sales's example before lunch, which is what happens if you've got one Greek company with 10 subsidiaries in different member states, and assume for the purposes of this debate that a notice is served identically in each of the 10 member states in relation to the subsidiary. It's for each member state to determine whether or not that notice is valid. Each member state may well have different rules in relation to whether or not a notice is validly served. For example, on capacity issues, there may be a presumption of capacity that can only be rebutted by certain sorts of evidence. For example, there may be limitation periods that make it too late to rebut the presumption. For example, what may be regarded factually as not giving rise to... The test may simply be different. And it's the English court that is to decide that, because if you can have different courts deciding that issue, you can have irreconcilable judgments. And the way that you avoid the irreconcilable judgments is by making sure that only one court can determine the validity of company law notices in relation to the English company, and that is England. You could have, if you didn't give exclusive jurisdiction to England in a case like this, and you had two directors in different jurisdictions, you could end up in a situation where two separate actions were brought, raising the precisely same issue. The way you avoid that is by saying where the subject matter is the validity of the notice, only one court can deal with it. The disagreement, or what underlies the discussion and the disagreement between myself and Mr. Crowe, my friend Mr. Crowe, is, can you just say as, and this is not being, both my Lord Briggs and my Lord Sales are saying, oh, well, surely if it's, and my Lady Black as well, well, this is really about the Turkish company. That is if you're enabled in these proceedings to step back and say, just make an evaluative judgment about what the sort of main issue is. I respectfully submit that the way that 24(2) is drafted and its intention and the way it's been construed by courts subsequently is to focus the court which is determining the issue of jurisdiction on what is the claim. And the claim is what is the legal right being asserted and what is the relief being sought. The legal right being asserted here is that this is an invalid notice. The relief being sought is, as a result, you can't have a general meeting on the basis of those notices. First, because you didn't have the authority to issue those notices, and second, because you can't change the rules, the Articles of Association in any event, because there's no written consent from Mr. Aiken-Ipek under Article 26. The error that my friend Mr. Crowe is seeking to lure the court into is to say, well, look, there's going to be lots and lots of evidence about what's going on in Turkey, which there will be for the purpose of the English law question, do we recognise the orders that have been made in Turkey? But it's not about the weight of the evidence, which would be, I would respectfully submit, an uncertain guide as to determine jurisdiction. Much better that you focus on what is the claim about, i.e. what's the legal right being asserted and what's the claim being sought. Lords, can I take you to Schmidt? Schmidt is a 24-1 case, not a 24-2 case, but it does have instructive passages in it. There was, you'll recall, the facts of the case were there were two claims. One, the guardian of the father sought to set aside the gift of the property in Austria to the daughter. The daughter lived in Germany. The daughter said, you can't sue me in Austria because that claim is not within 24-1, because it's not a claim in respect of immovable property in rem. The way that the court analysed it said there are two claims here. One, to set aside the transaction between the father and the daughter, which is only an action in personam, and therefore not within 24-1. However, the action to remove her ownership from the register of land in Austria is an action within 24-1, because that is an action which in effect determines his ownership ergo omnes, and it's only a claim erga omnes, which I take to mean against all the world, which is truly to be regarded as an action in rem in respect of immovables. There is another issue before you get there, which is because the convention excludes claims in respect of mental capacity, is this claim outside the convention altogether? And if you look at the Advocate General's reasoning at 918 AG 30, now, the significance, I submit, of AG 30 is what's being put is, well, this is really, the first claim is really about the mental capacity of the father, is what's being urged, and therefore you should treat it as outside the convention, because issues about capacity are not inside the convention at all. And what the Advocate General is saying, no, the fact that it might be the main issue is not really what the claim is about. The claim is about, is the gift valid? And that is within the meaning of the convention. Now, it's not a 24-2 issue that the Advocate General is dealing with there, but it's exactly the same approach as I am urging on this court. And if one goes to the judgment at para 25, which is MS page 927, the court agree with that approach if you read paragraph 25. So I rely on Schmidt, both from the Advocate General and the judgment of the court, to say, for the purpose of whether the convention applies at all, look at the nature of the claim, don't look at where the weight of the evidence may be. And that, I say, by parity of reasoning, should be applied to 24-2. If one go, what the Advocate General then does in her judgment, in her opinion, sorry, is she identifies that there are two distinct claims. Look at AG 33, which is MS 918. She then says, in considering what is meant by a right in rem in immovable property, she then says, in effect, don't take a local law approach to this, take an EU law approach to this. And then if you look at her AG 39 to AG 42, she says it's not a claim in rem in immovable property because it's only a personal dispute between father and daughter, or the guardian of the father and the daughter. So it does not fall within 24.1. And then if you read 2, AG 43 to AG 46, she then comes to an opposite conclusion in relation to the removal from the register claim. And then AG 46 on that basis, and that basis is this is the way you establish your ownership of the property against all the world. On that basis, one must proceed on the footing that the claim for removal of the defendant's right of ownership in the land register, by contrast to the claim for gift of falls within Article 24.1 of the Brussels 1A regulation. She then, in 3, addresses the issue if one is in the claim, if one is in 24.1 and the other is not, can one drag the other in? And she concludes that it cannot. Each claim has to be dealt with separately. But she then saves the day by saying, if you look at 8.4 of the Brussels regulations, if you look at 8.4, which are to be found at MS 914, bottom of the page, what she in effect says in this bit is, but don't worry, they can both be tried in Austria because there's the claim in rem and immovable property in relation to the removal, and the gift she treats as a contract claim. And that is AG 51 through to 58. And then, if you look at the conclusion she reaches at AG 59, she says, the setting aside the gift not within 24.1, the removal claim is within 24.1, but they can be combined because of 8.4. Now, I submit that although it is 24.1, and although different principles apply as to why it's sound justice to have actions in rem in relation to immovable property in the state of where the property is, it's to do with it. Jenner says it's to do with the fact you may well have to look at the land, measure the land, and it's far better that you're near the land when you're doing it, which is a different principle from that which applies to company law. The way that you analyse the claims for 24.1 should, in my respectful submission, be similar to the way that you analyse 24.2. And the way that they analyse the claims in Schmidt is to identify with precision what is being sought and treat only those claims which, with precision, involve a claim which is good against all the world, in order to give the in rem aspect, as being within it. And even though there are two claims which it would be very convenient to try together, and they find a way by which they can try them together, they are strict in the way that they determine what is within and what is without. And it is that sort of approach, I respectfully submit, that both Professor Génard and the CJEU is in effect adopting in determining whether 24(2) applies. Not, and this is not intended to be disrespectful to my learned friend Mr. Crowe, but a flabby, evaluative approach as to where is the heat and burden of this case going to focus. Now, I don't think I need to go to Eon unless you want me to, because I think Eon is an interesting case because as I said before, Eon has a lot of material setting out what the basic principles are. Eon is interesting because even though there's not a validity issue, although they talk about partial invalidity in relation to the price of the shares, what I submit the CJEU is doing, look very carefully to see whether or not this would be the sort of action you would expect to be covered by 24(2). You would expect it to be covered by 24(2) because it's entirely about the application of corporate issues in relation. Even though there may not be a particularly difficult issue of corporate law, nevertheless you'd expect it to be there. So applying it strictly does not mean applying it literally. But you get a lot out of Eon in relation to the basic principles. Now, could I just go back to the Court of Appeal in the light of that analysis? And it's, in my respect, it's clear from 44 to 50 that what the Court of Appeal do, and this is 45, I agree with the judge that far from being severable, the two issues raised in the claim against Koza are inextricably linked. Both are concerned with the validity of decisions of the shareholders in general meeting to replace the board of directors of Koza Ltd. Both issues are preconditions for a valid decision of an organ of the company. So much is clear from, in particular, the claim form and paragraph 34 of the particulars of claim. I'll take you to those in a moment, but they, I respectfully submit, just as Mrs. Justice Asplin and just as Mr. Justice Snowden did, focus on this is about the invalidity of the notices. There are two grounds for attacking them, but they've got it absolutely plumb right. For paragraph 46, I do not take from the English or European authorities, which were cited to us, any suggestion that one is required to, in all cases, to disentangle issues which are interlinked in this way and apply 24(2) to each issue separately. Now, I respectfully submit that Lord Justice Floyd is warning against the sort of approach that Mr. Crowe is saying. What he means by that is you don't say, well, there's an issue about the extent to which English law will recognise foreign judgments in Turkey. So we seek to try and weigh up the extent to which that is what the case is really about. He's saying, I respectfully submit, once it's been determined that the case is about the validity of the notices, you don't start to chop the case up into individual issues to see which is the predominant issue.
But I mean, can I ask, why wouldn't paragraph 46 be a criticism of the approach in Schmidt?
Because in
Schmidt, where they did, I accept it's an Article 24(1) case rather than 24(2). But
because he deals at the last sentence.
Okay.
The position is obviously different from a case where two quite independent claims are being made in the same proceedings. So if the position were that he regarded the claim, he being Lord Justice Floyd for these purposes, being the validity of the notices, and that's it, and there are two grounds upon which you can set aside the notices, there is only one claim with two grounds to it. Suppose the position were, I wish to set aside the transfer of the property from the father to the daughter on two grounds, one, lack of capacity, two, undue influence. Would that be one claim, namely to try to set aside the gift, or would it be two claims? I respectfully submit it would only be one claim. And that is what Lord Justice Floyd is saying in 46. I submit, I mean, if you are thinking, if it was thought, if it was being said, oh, well, the issues are so far apart that they constitute, quote, two independent claims, that would be straying into the wrong approach. Because then what you would be seeking to do would be to evaluate which is the more significant of the two, which is not what the CJEU cases are telling you to do. They're telling you to say, what's the relief being sought? What's the basis of the relief? Namely, that the notices are invalid. That's enough.
But I mean, I would have thought that in Schmidt, one couldn't say there are independent claims. It's only because the gift is set aside that there's a rectification of the register.
Yes, that's true, but they are different sorts of claim. That is the point that the court is making and the Advocate General is making. And they are clear, you've got to look at them separately.
Yes, thank you.
Could I not perhaps go through all the English cases, but just apply my approach to the English cases. And if one looks at the English cases, they are generally rightly decided, but maybe on a slightly different sort of analysis to the one that they give at the time, with the possible exception of new therapeutics. I don't know if you've had a chance to look at the English cases. New Therapeutics is a case where there was an English company. It basically carried on its affairs in France, primarily. And at a meeting, at a restaurant in the Eiffel Tower, people who were directors entered into an absolutely appalling agreement with the main customer of the English company. Those are the facts, and I will then take you to what this very gripping case decided. It's in Flag 10, MS 656. And if you just go, just to see what the claim was about, what the nature of the claim was, if you go to 658, you see the word summonses just below letter H on MS 658. By a written statement of claim dated the 31st of March 89, the plaintiff, New Therapeutics, alleged inter alia that the defendants, Dr. Louis Katz and Jean-Pierre Lablanchy, who at the material science were directors of the company, had in breach of the duties of fidelity and good faith, which they owed to the company, signed documents purporting thereby to sign on behalf of the company, although no board meeting had been called at which the validity and contents of the documents could have been discussed, were thereby acting ultra vires their powers of directors, and that the plaintiffs had in consequences suffered loss and damage, and the plaintiffs therefore claimed damages and interest thereon at 15% per annum pursuant to, etc. There's no defence that's filed at the time Mr. Justice Knox has to decide whether this is within the forerunner of 24.2. If you go to MS 678, Mr. Justice Knox, the statement of claim alleges breaches of duty by the defendants as directors of the company. There's no plea of any breach of any other contractual relationship between the plaintiff and the defendants. The particulars given of the breaches of duty complained of fall into two classes. First, there's the class of claim that the variation documents were signed in the absence of a board meeting. And then second, there is the claim put in various ways that the transactions contained in the variation documents were so detrimental to the company that no reasonable board of directors or directors could properly have entered into it. And then, in my judgment, the latter type falls outside 16.2 in that the substantial issue concerns the propriety of the individual director's action. On the other hand, the other type of claim, in my judgment, falls on the other side of the line. So you've got one claim of breach of duty, one allegation of the breach of duty is entering into a contract without the authority of the board. The other is entering into a contract so spectacularly awful that it was a breach of your duty to do it anyway. And then he considers this, and then just above letter C, I am therefore left with the final question: which of the two types of claims of breach of duty made by the company against the defendant raises the principal issue? They are of equal theoretical importance in that the company would win the action if it wins on either. No particular yardstick was suggested on either side to solve this conundrum, although not surprisingly, each side identified a different issue as the principal one. The issue upon which the defendants are, so far as this court can tell, the more likely to lose is likely to be the principal one, because they only have to lose one to lose the action. The other issue on which they are more likely to win is going to be irrelevant, unless, of course, the forecast is wrong. It must be a matter of judgment, which is the principal issue, even with the assistance of that test, and my judgment, which I do not propose to elaborate, is that the issue regarding the absence of a board resolution and the need for it is the principal issue in the case. It therefore follows that I consider that Article 16.2 does apply, and this court has jurisdiction. Well, now that's with the greatest of respect to Mr. Justice Knox, that's unsatisfactory. And that is unsatisfactory because if the test was predictability and certainty, and this is not any disrespect to Mr. Justice Knox, it depends upon an exercise of evaluation that is, it's not capricious on the part of the part of the judge, but it's inexplicable because he says I'm not going to explain it beyond what I've said, and that can't be the right approach. I respectfully submit that probably the answer to the new therapeutics case is that it is outside 16.2 because in reality it should be regarded not as a validity of the organs case but a breach of duty case by the directors. And therefore there were two sets of particulars of breach of duty, and that would be the answer to that case. If one goes to Grupo Torres, which is
Sorry, just on that, am I right in thinking that there was an agreement entered into and it was a valid agreement?
Yes.
And then the company comes against the directors that's caused it to enter into that?
Correct, that's exactly
how it worked.
Yeah. That's the agreement with the third party.
Yes,
that's absolutely right. Grupo Torres, this is a case in which my Lord Briggs was in the Court of Appeal, so he will have a total recall of all of the facts and matters. The Grupo Torres case involved a massive fraud by the person who was the chair of the Kuwait Investment Office by a variety of separate frauds. Those frauds involved a Spanish company called Grupo Torres. The defendants sought to stop the proceedings in England on the basis that what this case involved was the validity of acts that had been done by the Spanish company. Mr. Justice Mance, as he then was, rejected that contention, in effect saying, no, this has nothing to do with, in reality, the validity of the acts of the Spanish company. This is about the misappropriation of funds by a fraudster, in effect. And in effect, the Court of Appeal came to the same conclusion. If one just goes to what Mr. Justice, I submit that the decision is obviously right in Grupo Torres. This is plainly not a case to be covered by the forerunner of 24.2. Could I just take your lordships to MS 538, which is Mr. Justice Mance, first of all. And Article 16.2 is 24.2's predecessor. And I just ask you to look at the bit at the very bottom of the page. Article 16.2 calls for an exercise in overall classification. No submission was made that under Article 16, the various claims made by the plaintiffs, or indeed each plaintiff against the defence, might constitute separate proceedings. All parties proceeded on the basis the present multi-partite action constitutes a single set of proceedings for the purposes of deciding whether there is any assignment of exclusive jurisdiction under 16. In this respect, as will appear, there was a significant contrast with certain submissions addressed under Articles 21 and 22. I simply refer to that bit because it's clear that the case proceeded on the basis we're not going to break up each individual claim. Then, if you go to 404, he sets out the rival contentions. The rival contentions is under the plaintiffs say this is a claim about fraud. That's from the rival contentions down to the exclusive arena on 404. And then the defendants, on the other hand, maintain that this case is essentially about the conduct of the affairs of GT by officers of GT pursuant to and or ratified by decisions of the board of GT and or GT's main and ultimately only real shareholder, the KIO, through its subsidiaries. They also say that the claim by THL must be regarded as a make-weight. So they're saying this is really about the validity of what's been done. And then his conclusion is at 408.
Oh, right.
MS 543, sorry. And then basically what he's saying in that conclusion, and it's only that bit that your lordships need to read, your ladyship needs to read, that he's effectively saying, no, this is really about the fraud. And then if you then go to the Court of Appeal, which is flag 7, Lord Justice Stuart Smith, delivering the judgment of the Court of Appeal, analyses the various contentions. On the way there, at 597, he says that in New Therapeutics, Mr. Justice Knox should have held they were both within 16.2, and I'm saying that he should have held they were both outside 16.2, but that's by the by. Then if one looks at the top of page 598, want or excessive authority, however, is one thing. Abuse of authority is quite another. Honest but misguided directors who faithfully record their actions and purpose and conduct themselves openly as the appropriate organ of the company, commit the company to a transaction which they mistakenly believe be for its benefit, may be liable for acting beyond the scope of their authority if the transaction is not and could not reasonably be thought to be in the company's, but that is not the present case. And then basically, he says it's about fraud. And if you get that, and such a case has nothing whatsoever to do with any decisions of the plaintiff's organs. If the plaintiff's allegations are true, and on an earlier interlocutory application, Lord Justice Stayne has acknowledged that they are supported by prima facie evidence of a sophisticated fraud, those of the defendants who were officers of the plaintiff were not acting openly and honestly as organs and for the benefit of the plaintiff, but secretly and dishonestly for their own personal benefit and in fraud of the plaintiffs. And that, and then if one just goes to the bottom of that page, the subject matter of this action remains the frauds which it is alleged that the defendants have practiced on the plaintiff companies. The object of these proceedings is not decisions of the organs of the Gruppo Taurus, nor for that matter of Taurus London. That is obviously correct. And then finally, if you go to Zavarco, which my friend Mr. Crowe took you to, and in the issue in the first of the cases is about a meeting. It's MS 794. Sorry. The issue is the validity of a meeting, and that depends upon what percentage of shares Mr. Not Mr. Blomquist, the other side had, and that in its turn depended on the terms of a written agreement. And then if you just read 19 and 20 of Mr. Donaldson's judgment at page 804.
Sorry, page?
MS 804.
804.
Sorry, yeah. I submit that what Mr. Crowe is urging the court to do is to do that which Mr. Donaldson rightly rejected, which is to view the issue more widely than simply what the claim is about, which is, as he then says at paragraph 20, undermining the certainty and predictability values that are sought to be maintained in the convention. If you go over the page to paragraph 24, he analyses BVG, and then his conclusion on what BVG, this is in the ECJ, decides is at just above letter G. The Court of Justice answered the question in the negative, ruling that invocation as a defence of an Article 24 matter does not affect the contractual or non-Article 24 nature of the proceedings. It is clear that the decision was not based on any overall evaluation of multiple claims or issues, but simply on the basis, see paragraph 23, that the plea of corporate invalidity was a collateral or preliminary issue in a claim relating to a contract. I submit that what Mr. Donaldson is saying there is, in effect, you look and see what the claim is really about. The fact that there are issues that raise what might be 24.2 type issues doesn't bring it within 24.2. And then in 29, he's dealing with not, in 29, he's dealing not with the issue about 24.2, but about the exception in 24.3. This is MS 806, which is about public registers. And if you just read paragraph 29, again, what is being sought is to try to widen it, and he brings it back again to as it were, the face value issue, which is it's about a public register, therefore it's within 24.3. I submit he's right in relation to the way that he looks at it. In relation, there's one other case I would ask you to look at, I won't take your lordships to it, but it's called Speed. It's, at first instance, Mr. Justice Lewison, as he then was, at flag 11, and the Court of Appeal, in which Lord Justice Carnwath, sitting with Lord Justice Newberger, as he then was, and Sir William Aldous, which is flag 12. The issue that they are confronted with is the composition of the board of the company that runs Formula One motor racing. And the question was, were a number of directors validly appointed? The question of who would be appointed directors depended in part on a shareholders' agreement. The argument that was being advanced to say that this was not within Article 24.2 was that, well, a shareholders' agreement comes into the issue as to what the composition of the board is, held both by Mr. Justice Lewison and the Court of Appeal. The fact that there is a contractual issue on the way does not prevent this case being concerned with Article 24 Rule 2 issues, namely the validity of the organ of the company, because that obviously depends upon the composition of the board of directors. And it is an example of a situation where you don't get distracted by the fact that one of the issues is not a company law issue.
I mean, rather curiously, the court doesn't refer to the cases that we've been looking at.
In Speed?
The Luxembourg cases, yeah. They refer to Gasser, which is on a different point altogether, and they do refer to the Reichert case, which at least is in the right area. But they don't refer to Hassett or BVG and so on.
No, I mean, it's because it's decided in 2004, and BVG is much, much after
right.
that. Schmidt is after that.
Yeah.
Eon is after that. The only one they refer to, which we've looked at, is Grupo Torres and New Therapeutics.
Yes, I see. So this is really quite an early decision in terms
Yeah.
of the development of the case.
Yeah. Could I move from the analysis of the cases to the analysis of the proceedings? I mean, my learned friend took you to the amended points of claim, particulars of claim. The position in relation to the particulars of claim is that although leave has been given to serve the application for leave to amend on the additional parties, leave to amend has not yet been given. The basis upon which the case was therefore looked at before all two previous courts, because there weren't particular claim before Mr. Justice Snowden, is on the unamended pleadings, and that's probably the best one to look at for the purposes of this judgment, because it may be in the light of what your lordship say, questions of what may or may not be allowed by way of amendment may arise. But I think strictly your lordship should look at the particulars of claim, which has to be found at MS 205. Could I take you to MS 216? And the amendment is the same in this respect. Claimant's case on why the Section 303 notice was invalid. Section 303 notice was invalid because the trustees have no authority in this jurisdiction to cause Koza Ltd to do anything as a shareholder of the company, and in any event, the Section 303 notice was invalid as a matter of English company law. The first of these grounds has already been explained. The second ground is explained below. And what you get from paragraph 36 through to 41 is the point about Article 26, in respect of which there is no dispute, that is within 24(2). The issue being that, in effect, Mr. Aiken IPEC has an entrenched right to remain a director. You can only change that if he's given his written consent, and he hadn't given his written consent. And that is one of the bases upon which it is said the notices are invalid, because you can only serve notices if you can pass a motion that is valid. As is plain from paragraph 34, the other ground on which it is said the notice is invalid is no authority in this jurisdiction to cause Koza Ltd to do anything as a shareholder of the company, and that's 34(1). If one looks at para 45, the relief that is being sought, it is 1, a declaration that the notices were ineffective, 2, an injunction to restrain the defendants from holding or purporting to hold or procuring the holding of any further meetings pursuant to the Section 303 notice, a declaration that the English courts do not recognise any authorities of the trustees or anything to cause Koza Ltd to call any general meetings of the company or to do or permit the doing of anything else as a shareholder of the company, and the company is Koza Ltd, not Koza Ltd. And insofar as necessary and or appropriate, an injunction to restrain the trustees, whether individually or separately by themselves, their servants, agents, proxies, or otherwise, from hold themselves out as having any authority to act for or bind Koza Ltd as a shareholder of Koza Ltd, and from Koza Ltd to do anything or permit the doing or anything as a shareholder of the company. I don't think I need to look at any of the rest of the pleadings. My submissions on the proceedings is the proceedings are concerned with whether the notices are valid, and flowing from that, whether the shareholders of Koza Ltd can change the directors. The issue in reality is the validity of a proposed general meeting of an English company. This is the only subject matter of the proceedings. I've shown you the way that the judges in the courts below analysed it. There is no dispute that the company law issue is within 24(2), and the company law issue has the effect of invalidating the notices purporting to require the directors to call the general meeting. If it is accepted that the company law claim invalidates the notices on that ground, it must be implicit in the appellant's position, as the Court of Appeal records, that a decision of Koza Limited's organs are equally under attack by the authority claim. In both, the relief sought is the same. In both, it is the invalidity of the notice that gives right to the claim. Could I just refer your lordships to what was said about that by the Court of Appeal at MS 168. It's in particular the last sentence of paragraph 47. So the point that the Court of Appeal is making, which I adopt, if you can attack validity on the basis of the company law point, and that's within 24.2, if you attack the validity on the basis of the authority point, that also must be within 24.2, because there is no dispute that attacking the validity of the notices is within 24.2. Could I then, in the light of what I've said, then go to the two big grounds of appeal? First of all, the authority claim as against Koza Ltd. It is said that that is not within 24.2. What is said to make it not within 24.2? If you look at the written case and what was said orally today, there are in effect two reasons given. The first is because of the striking consequences of it being within 24.2, and secondly, because of the inextricably linked point. First of all, the striking consequences. What is said in the written case, though it was not said orally, is that if you were to allow this case to go ahead, then you would in effect be making the English court the court of exclusive jurisdiction to decide whether or not, for example, a contractual notice issued by Koza Ltd. was valid. That extravagant consequence is not the consequence of what we are submitting for. If there was a dispute about whether or not Koza Ltd. had validly served a contractual notice, that dispute being based upon whether or not the trustees had authority to procure Koza Ltd. to serve the notice, that dispute would arise in the context of a contractual dispute. So no decision being made here in relation to whether or not the court can consider whether or not Koza Ltd. could serve a notice in respect of Koza Ltd. has that consequence, because the dispute here is about the validity of the Koza Ltd. notices. Secondly, he complains, Mr. Crowe, that we are seeking to use the company law point to pull in the authority point. Wrong. We say the authority point is there not because of the company law point, but because it attacks the validity of the notices. And it follows from that that if the only point in the case were that the notices seeking to convene the general meeting of Koza Ltd. Were invalid because of the authority point, and only because of the authority point, we submit they would still be invalid. You don't need the company law point to make that so. And then second, it is said that the extreme consequences of it being held that the English court has exclusive jurisdiction here is that you end up as parties to those proceedings people who the Court of Appeal have said are not, quote, necessary parties. Again, we would submit that that is wrong for the following, in effect, 6 reasons. First of all, 24.2 focuses on subject matter, not defendants, and that is in sharp contrast to the other provisions, in particular sections 2, 3, 4 and 5 of the Convention, which focus on the defendant. Secondly, because the concept of necessary party is not defined either by Mr. Crowe or by anybody else. The court is seeking to construe a convention that has an autonomous meaning to say that unless you are a necessary party, you can't be joined to an action whose subject matter is the validity of the acts of an organ of a company. Must be wrong. It would lead to great uncertainty. Thirdly, as the court in this case finds, the Court of Appeal, there was no suggestion that the defendants weren't properly joined. They were properly joined on the basis that they were the people who had procured the service of the notices. Therefore, it's right that they have an opportunity to be heard. If they were properly to be joined, and the subject matter of the proceedings is a 24.2 matter, then the court should have exclusive jurisdiction over them. Fourthly or fifthly, I'm not sure where I am, in BVG, in the Court of Appeal, Lord Justice Aikins rightly rejected an argument similar to this. If one looks at which paragraph is it? Is it there? Paragraph 21, thank you.
Page?
Page MS 614. Before the judge, Mr. Rabinovitz for JPM first argued that Article 22.2 applied only to disputes between a company or other legal entity and its officers or shareholders, and that the article did not extend to disputes between the legal entity, officers or shareholders, and third parties. In other words, he argued that 22 was confined to internal disputes in the company. The judge rejected that submission. Secondly, Mr. Rabinovitz argued that when considering whether Article 22.2 applied, the court should not look at any defences raised, but only the nature and scope of the claim itself. The judge also rejected that argument. Although both these conclusions were the subject matter of respondents' notices were dealt with in JPM's written submissions before us, Mr. Rabinovitz did not address any oral argument. I agree with the judge's conclusions on those points, and I do not need to say anything more about them. And the bit I rely on applied only to disputes between a company and its officers or shareholders, and that the article does not extend to disputes between the legal entity, officers or shareholders and third parties. So he's rejecting a restriction based upon who the defendants are.
He's also rejecting the sort of just look at the claim.
He is.
Or by associating himself with the judge's rejection of it.
That is pre the BVG and the CJEU, okay, though it is on the way there.
Just.
Yeah. But, I mean, I submit he was wrong about that. He was wrong about that for all the reasons I gave in answer to the point that I gave you. So, I mean, boil it down. the extravagant conclusion, it is alleged by Mr. Crowe, that comes from allowing non-necessary parties is not so extravagant if the court concludes that they are proper parties and the court concludes that the subject matter of the proceedings is a 24(2) matter. Then it is right that the English court have exclusive jurisdiction in relation to that. And then, my Lord, there are, in effect, 3 errors that are then alleged in relation to this first appeal, namely we should have excluded the authority claim from 24(2). The first is, he says, the Court of Appeal erred in treating the 2 claims as inextricably linked. I think I've dealt with that. My submission in relation to that is the basis upon which the Court of Appeal and indeed Mrs. Justice Asplin and Mr. Justice Snowden treated them as inextricably linked is that they both attacked the validity of the notices. And that was an entirely proper basis on which to treat them as linked. The next error alleged is in relation to, quote, the interpretation and application of 24(2). And I think one will find that I've gone through most of these points already. At paragraphs 57 to 62 of the appellant's written case, which is to be found at MS 105, Mr. Crowe makes the allegation that the Court of Appeal has allowed a party to tack on the authority claim, which is outside 24(2), onto a claim which is within 24(2), which is the company law claim. And again, I've dealt with that. I say they're both within 24(2) because they both attack the validity of the notice. Then at paragraph 61, he alleges, this is paragraph 61 of the written case, in accordance with Schmidt and Hassett, the court should not apply an overall classification approach. Instead, he says they must look at each individual claim. Again, I'm not sure that we're that far apart in relation to that issue. The issue is not, does one adopt a Schmidt-type approach? I submit that one does. The real issue between us is how does one classify the 2 allegedly separate claims? And I submit they're not separate because they're both an attack on the validity of the notice. And then paragraph 62 of the written case, he alleges that the Court of Appeal didn't look at the principal subject matter of the claim. Instead, they focused on the fact that the authority claim could have a knock-on effect on the internal affairs of Koza Ltd. And that knock-on effect approach is one that he adopts in his oral submissions. Again, I've given my answer, no. The fundamental relief being sought is to say that the notices are invalid, not just for the authority claim, not just for the company law claim, but because of the authority claim as well. Then he says that the Court of Appeal erred in 4 respects in the way that they characterised the pleadings. He contended, and he didn't repeat, he contends in his written case at paragraph 64 that the Court of Appeal erred at paragraph 48. Can I just take you to paragraph 48 of the Court of Appeal? Which is at MS 168. What he says about that in paragraph 64 of his written case is the Court of Appeal got it wrong because there's no dispute that Koza Ltd could act as a shareholder of Koza Ltd. That's not in dispute, and therefore they've characterised it wrongly. But I respectfully submit that's a misreading of paragraph 48. It's plain that what paragraph 48 is directing its attention to is, did the trustees have the authority to cause Koza Ltd to vote in a particular way? So that first error is hopeless. Then he says in paragraph 65 of the written case, which is MS 107, that the Court of Appeal failed to reflect the breadth of the relief being sought. And that point is getting to the point that the declaration in 4 and the injunction in 5 are directed to stopping Koza Ltd acting as a shareholder when directed to do so by the trustees of Koza Ltd. Again, we submit he's wrong about that. Both Mrs. Justice Asplin and the Court of Appeal expressly recognised the width of the terms of the relief sought. And I can just take you to, first of all, the Court of Appeal at paragraph 49, MS 169. So it's 48. 48 and 49. That view of the proceedings is consistent with the way in which the action is pleaded in the particulars of claim. It is true, as the judge also observed, that some of the relief claim might appear in isolation to go further than a challenge to the authority of those purporting to act for Koza Ltd in relation to Koza Ltd. Read as a whole, however, in particular taking account of the way the case is pleaded in paragraph 34, it is a challenge to the ability of Koza Ltd to act as a shareholder of Koza Ltd in relation to Koza Ltd's internal affairs. And if one goes back to Mrs. Justice Asplin, if one looks at paragraph 48, MS 191 of her judgment,
Manuscript.
MS 191.
Thank you, sorry.
So although there is a reference to restraining them from voting Koza Ltd shares in Koza Ltd, both the Court of Appeal and Mrs. Justice Asplin characterise that as being in the context of the attack on the notices. Then the third attack on the characterisation, which is paragraph 66 of the written case, is that the court is wrong to ignore that the weight of the evidence will fall on the authority issue and not on the company law issue. I submit that that is not the right approach, that the right approach is to look and see what the claim is, and I've gone through that many times. And then the fourth attack on the characterisation is that it is alleged in paragraph 66 of the appellant's written case that Mr. IPEC's principal purpose in bringing these proceedings is to ventilate his grievances against the Turkish government, and that should have been taken into account. That was abandoned in oral argument by the first proposition advanced by Mr. Crowe that motive doesn't matter in relation to that, and indeed the Court of Appeal expressly record that that was conceded below, and so it couldn't be run anyway, and that's at paragraph 28 of the Court of Appeal's judgment at MS 164. My Lord, in my respectful submission, my Lord and my Lady, these 4 points are hopeless as a matter of characterisation. Separately from these points, we, the respondents, contend that there is no legal basis in any event for interfering with the decision of Mrs. Justice Asplin or the Court of Appeal on the question of whether the proceedings are properly to be characterised as having their principal subject matter within 24(2). And this is the point that we talked about before lunch, which is this is a characterisation issue. Lord Justice Aitkins deals with it at para 97 of his judgment. This is a moment where I say Mr. Lord Justice Aitkins was completely right. This is paragraph 97, it's set out in the core bundle at MS 141. Paragraph 97. Have you got the sales one? Sales. Thank you. I submit the place where it might be relevant is when you are dealing with how the courts below, Court of Appeal and Mrs. Justice Asplin, not Mrs. Justice Snowden because he didn't have the particulars of claim, characterise, is it too wide? Because that's a judgment that they've got to make, and you should leave it to them. My Lord Sales referred to the decision of his, which is, I think, JSC, BTA Bank and Abliazov,
that was my
number
best
14.
Memory, yeah.
Could I hand up hard copies of this? And maybe, if those, I'll try and get it put on the system in some way or another. And the bit I think that
And this case came up to this court, and I don't think this bit was commented on one way or the other.
I didn't know that. My understanding is that the issue is the extent to which an application to stay proceedings on the basis it should be sued in Switzerland depended in part on what para 5.3 of the convention said in relation to the place of the harmful event. And then your lordship, my Lord Sales, at para 71, the second para 71, at 909, and sorry. And I submit with appropriate tentativeness that what my Lord Sales is getting at there, and what Lord Justice Aikins was getting at in the BVG cases, where you've got to make an evaluative judgment, even though it is to some extent a legal judgment, we will be reluctant to interfere in the higher courts unless there is really only one conclusion that could have been reached. And what you've got here is Mrs. Justice Asplin having to make a judgment about how you evaluate the claim. She plainly applied the proper test, as did the Court of Appeal. To the extent that there are choices, you should leave those choices to the first instance judge. And my Lord, that's all I want to say on the first ground of appeal, namely the authority claim should be treated as outside. In relation to the second ground of appeal, namely the position of the former trustees, I think I've set out all of my points in relation to it. It's about the subject matter. Necessary party is not a concept known to European law. It's not disputed that they were proper parties and properly joined. You lead to uncertainty if you make this rule. No other case has ever suggested there is this rule. It goes against the objective of 24.2, which is to say where decisions are going to be made about the constitution of a company or the validity of its acts, that should be decided by its lex incorporaneous, the courts of the place where it's incorporated. That doesn't turn on who the defendants are, it turns on the nature of the decision, the subject matter of the case.
Can I just ask you something on the basis that you were to prove to be wrong and only the company law aspect of this remained within the jurisdiction? What would then happen about the strikeout application, which depends upon the authority matters?
The strikeout application would continue because we submit that the trustees do not have authority to instruct solicitors. So the case would continue effectively constituted as it currently is, with both claims before the court at the moment. On the basis I'm wrong about the authority claim would drop out as one of the attacks on the validity of the notices, but the court would have to decide whether or not the defendants could give instructions in relation to the case, and that point, Mrs. Justice Asplin decided, would be determined at the trial of the matter. So the issue would still arise for decision.
She presumably did so on the basis that she thought it was within Article 24.
She didn't say.
Or had that point not then been
she
decided?
said it was a case management decision.
But what was the timing?
So what was it?
When did she make the strike out, adjourn it to trial decision?
She made it at the same time as she heard the application to say that it was not within the jurisdiction of 24(2).
Right. So she was doing so at any rate at the same time as deciding
Yes,
that the point was
she
within
was.
24(2) anyway.
Yes.
Yeah.
There was an appeal in relation to the point which was rejected.
It's paragraph 64 of the Court of Appeal is really the central paragraph about it, isn't it?
Yeah. And actually, what the Court of Appeal are saying is that strikeout loses its utility when both points are in play. But if both points are not in play, then it regains its utility under the strikeout.
Now, Lord
So
Faulkner,
sorry, just can I?
Yes.
So as far to say it's not within 24(2) would then lead to the conclusion that a strikeout becomes all the more important. Not you can just dispense with it.
I'm afraid you're going to have to leave some time for Mr.
Of course,
Crowe
no, I've
to,
stopped. I was standing,
Yes.
waiting to be asked any questions, not trying to keep on going.
Very well, thank you very much, Lord Faulkner. Mr. Crowe.
My Lords, can I just make a few points in response in the order in which they were made, starting, I think, with the main point of difference between us, which is that my learned friend said early on that his action comprises two bases on which the notices are being attacked. And he went through the courts below to show how they had agreed with him. That, in our submission, is not an answer to the main point of analysis that we are offering to you, which is to describe both claims as attacking the validity of the notices is doing violence both to the concept of the word validity and particularly in the context of Article 24(2). The English company law claim challenges the validity of the notices, and it does so in a relevant Article 24(2) sense, because it is challenging their legal effectiveness by reference to English company law principles. And my Lord Reid took my learned friend to paragraph 26 of Hassett, which specifically makes the point, as you will recall, paragraph 26 is tab 19 of the authorities bundle, pages 886 to 887, the provision must be interpreted as covering only disputes in which a party is challenging the validity of a decision of an organ of a company under the company law applicable. Now, our submission is that the authority claim is not challenging the validity of the notices, and it's not doing anything under the company law of England. It is not challenging the validity because the ruling that is being sought is not a ruling, to use the expression in one of the cases, erga omnes. It is not a ruling that the notices are inherently invalid. It is merely asking the English court to express a view as a matter of English judicial policy. A court in another jurisdiction applying a different policy might quite legitimately take a different view. So the authority claim is not a question of the validity of the notices. It is a question of the English court's attitude as a matter of choice and policy to whether they will proceed with the case on the assumed basis that there are any notices to consider at all. And it is important, it is a repeated feature, it's not just Hassett, paragraph 26. I would also invite your Lordships and my lady to consider in Grupo Torres, which is Authorities Bundle 1, tab 6, at page 543.
It's the expression special considerations of company law and
Exactly.
practice that you're referring to.
I don't think that these issues turn on any point of company law or practice or any problem associated with the decision-making activities of the Spanish company. And the same point was also made by the Court of Appeal in the BVG case, which is at tab 8 at electronic page 626, where at paragraph 88 of its judgment, and it is a useful phrase that is then repeated in some of the subsequent English cases. At paragraph 88, they say, in the context of Article 20, it's the last four lines, in the context of Article 22.2, this will not be the case unless overall the proceedings are so closely connected with the matters of local company law and internal corporate decision-making in respect of the company that the proceedings should not be tried anywhere but in the courts of the state where the company has its seat. And my learned friend's answer to the Hassett paragraph 26 challenge, so to speak, was essentially to retreat and saying, well, English policy, English judicial policy is a matter of English law, and somehow that's good enough. And in our submission, it just isn't. Real sense has got to be given to the concept of a challenge to the validity of the notice, not a matter of choice by the English courts. And real sense has got to be given to the concept of a challenge by reference to English company law, not by reference to substantive questions of Turkish law and adjectival points of English public policy. So that, I apprehend, is the main point between my learned friend and myself. He then went on shortly after that to say that the issue is whether the English court should recognise what has happened in Turkey, and our answer to that is exactly so. That is precisely what the English company, the authority claim is about, and it is not within Article 24.2. My learned friend said we should have been taking you through the unamended particulars of claim, which we would be perfectly happy to do, because if you were to turn the pages of that, exactly the same points as I was making leap off the page. I don't ask you to do it, but you've got the page reference. It starts at page 205 in the electronic bundle, and point 1 remains, the appointment of the trustees was unlawful as a matter of Turkish law. Point 2 remains, the judicial process by which the trustees were appointed was contrary to natural justice. Point 3 remains flagrant abuse of Turkish criminal justice system. You get exactly the same points as we have seen in the proposed amendment, admittedly with slightly less evidential detail, but they remain exactly the same points of substantive Turkish law. Next point, my learned friend said that, he said this, where you are dealing with the validity of decisions of an English company, only one court should make the decision. That is wrong by reference to BVG. We have seen that BVG expressly, the European Court decision in BVG expressly recognises that the English court was entitled to make a decision about the validity of a German public authority's decision-making. But my learned friend's proposition is in any event wrong in relation to the authority claim because, as we say, that claim properly analysed is not a question of validity. It is a question of policy choice to recognise or not recognise. E.ON, my learned friend, the Czech case, says that involves an expansion of the application of Article 24 because it wasn't a case of invalidity. We do invite you to reject that analysis. My learned friend, I think, would be better placed if the Advocate General's opinion had formed the judgment of the court. The Advocate General got quite animated about the idea of effectively ignoring what Article 24 does say and simply treating it as a convenient device to assign all internal disputes in a company to the courts of the member state of incorporation. But that is not the approach of the court. The court takes a 100% orthodox approach, saying general rule, exceptions construed narrowly, purpose, as we have established, being to assign decisions to the courts which are best placed to decide them, and it was a question of invalidity, albeit partial invalidity, of the decision of the Czech company. The next point I just wanted to answer, my learned friend said that different proceedings in different jurisdictions risk different decisions being taken, and that the solution is exclusive jurisdiction. And in our submission, that is absolutely not the right approach. We have seen repeatedly from the case law, and it's evident from the structure of the regulation itself, that there are other mechanisms in place to avoid conflicting judgments. There is the ability to join parties if they are necessary or proper. There's the ability to stay proceedings in one jurisdiction in deference to proceedings in another. The fact that there might be a risk of inconsistent judgments in relation to related issues does not drive an expansive interpretation of the exclusive jurisdiction clause. It simply highlights the importance of the other mechanisms under the regulation for guarding against that. The case of Schmidt was his next point. He said that a preliminary issue was raised in that case as to whether the convention applied at all, because it was said it was a question of mental capacity. That is true, but entirely irrelevant, because that aspect of the judgment has nothing to do, the question of whether or not the convention applies has nothing to do with the interpretation of Article 24, which requires a strict approach, and that is simply not what the court was dealing with in that part of its judgment. What Schmidt does say, and Bernard has to accept, is that the classification of the claim for rescission outside the convention, outside Article 24.1, and the classification of the claim for rectification inside does demonstrate a segregated claim-by-claim approach to the operation of the exclusive jurisdiction clause. That is exactly what we are advocating. On new therapeutics, we are agreed. Melinda Friend, I think, was almost reading our written case on that. We can both agree that it provided an unsatisfactory test and should have been decided on the basis that the claim was simply outside Article 16. Grupo Torres and Speed Investments, I don't think we have anything useful to add to what we said in our printed cases. Could I just trespass a little bit? I think I lost some of my 15 minutes. I apologise, but I really won't be at all long. Just in terms of the structure of our main appeal, my learned friend said I had two grounds. One was the striking consequences, as he put it, and the other was the inextricably linked argument, just so that there is no doubt. Pointing out striking consequences is not in itself an argument. It is, so to speak, a red flag to put you on warning as to whether or not you are getting to the right answer. Our arguments are the ones under the headings Error 1, Error 2, Error 3. Errors 1 and 2 in our printed case are the point that the court should have analysed the two claims separately and appreciated that one was not within Article 24. And as we say, Error 3 is the point of principle. Error 3 is that the court, even if it should have been forming an overall evaluative judgment, simply got the wrong answer for reasons I don't think I need to repeat. So far as the former trustees are concerned, my learned friend's main point, both in writing and I think on his feet, seemed to be that the joinder of parties is not in terms covered by Article 24. And as he puts it in paragraph 124 of his written case, he says it's for the member state court seized with proceedings under Article 24 to decide whether a given defendant or claimant should or should not be a party by applying its own law. That reflects the fact that it is that court which is best placed to determine the dispute. So in the present case, it's the English law on parties that applies. As the Court of Appeal rightly recognised, the former trustees are proper parties. Now, with the greatest respect, that argument really can't be accepted. First of all, Article 24, being a rule of European law, has got to have uniform effect across the various member states. It cannot be dependent, its reach cannot be dependent on the procedural rules of each member state governing the joinder of parties. So the idea that the reach of Article 24 is dictated by English rules as to the joinder of parties, in our submission, it would be a heresy. In any event, the argument is entirely circular because it starts with the proposition it is for the member state court seized with proceedings to decide, which predicates the proceedings already being initiated and the court itself being properly seized of the proceedings, whereas the argument on jurisdiction is whether the court is properly seized at all in the first place. And the argument, in any event, doesn't provide my learned friend with any comfort in this case, because it proceeds on the assumed basis that the joinder of the party has been tested in some way by the domestic court, which is precisely what has not happened in this case. There was no application to join. There was simply a claim form issued and an assertion that the court doesn't look at who the parties are because it is a claim to which the court has exclusive jurisdiction, and exclusive jurisdiction, it is said, operates by reference to the subject matter, not by reference to the parties. So with the greatest respect, my learned friend's argument is circular and does not provide a principled basis upon which to regard the operation of Article 24 as applying to the former trustees, given the particular context that I've already outlined. My lords, I don't think there are any other points on which I need to reply. Unless there are any other points.
I don't think so, Mr. Crowe. Thank you very much.
I'm sorry I trespassed over.
Well, we are very grateful indeed to counsel for very well presented arguments on both sides. Unfortunately for us, they're both quite attractively put arguments. We'll now have to try to decide which one we prefer. In the meantime, the court is adjourned.